and at the time he is appearing before you, he is no longer insane?
That would have been, it would be a defense under the evidence law. Insanity is a defense. You can say that at that particular point, he did not know what he was doing.
All right, yeah. That's fair enough. But supposing at the time he committed the offense, he was not insane, but he subsequently became insane.
Thank you. So at the time of the commission of the crime, the person was insane, was sane. But in the course of the trial, you learned that actually the accused person, the mental capacity has somehow been impaired, and I would still apply the test of him first of all being taken for examination to ascertain if they can. So you've taken
him to a doctor. The doctor has certified really he's insane, but yes, he's insane now that he's standing trial. At the point in time he's standing trial, he's insane. But when he committed the offense, he was not insane.
At that particular point, I'm looking at the prosecution on whether they're going to make an application to have him discharged, and he can actually be brought back, should he be back to his normal state to stand trial. But an insane person cannot stand trial, my lady.
So he's going to be away for so long. We don't know when he's going to get, when he's going to heal. Anyway, you understand how difficult this subject is, eh?
Yes, yes.
Should a person who is insane be found guilty of a criminal charge?
First of all, they cannot stand trial. So I will not even proceed with the trial itself.
Okay. You know, okay. The other scenario, of course, was that at the time he committed the offense, he was insane, but now he's fit to stand trial.
That one would, he will proceed with the trial, but to him, I believe he'll raise it in his defense that at that particular time he was insane. So we'll proceed with the trial, but he'll bring it out during the trial process, and it will be his defense.
And if you find him guilty?
First
of course,
of all,
in his defense, what do you expect him to be saying?
In his defense, the accused person may say that at that particular point in time, I did not know what I was doing. So I will assess that.
I committed the act,
yes,
but I was insane.
Yes, my lady.
Do you acquit him?
This evidence has to be corroborated. And should I find it?
Let's not worry about that. He's making a confession himself.
Okay.
Yeah.
I would acquit him, my lady.
You would acquit him?
Yes.
But he's saying I'm guilty.
Yes, he's guilty. That particular point in time, my lady, he understands that, yes, what I did was actually an offense under the law. But at that particular point in time, when he was committing the act, he did not have the mental capacity
and
to
he has
understand
raised the
it.
defense of insanity. So do you acquit him or do you find him guilty?
I would acquit him.
It's a difficult conversation. It's an area that I think we've not come up with a firm conclusion.
Thank you.
And that's a topic for another day.
Thank you, my lady.
Thank you, Chair. Good afternoon once again, Council.
Good afternoon, Madam Commissioner.
Okay, I've gone through your sample writings.
Thank you.
You submitted legal opinions, submissions, and academic paper. I however note that 3 of your documents, that's submission and 1 legal opinion, they are not signed. So we can't really tell whether you are the author of the documents or not. That is question number 1 with regards to your document. And then number 2, the 2 legal opinions are internal documents. In fact, they are worded up there, internal memo. So you may have been required to seek consent before using them for public exercise like this one, or redacting some information. What do you have to say about those two questions?
Thank you, Madam Commissioner. In terms of the authenticity and whether I'm the author of those two documents, I want to categorically confirm that indeed I'm the person who authored them, and I think it was an oversight on my part not to sign them, Madam Commissioner. On the second limb of being an internal memo, I tried to retract and obscure some parts, but I understand it was not very clear. And two, being an internal memo, my employer is aware that I'm seated on this seat, so I would say that maybe I can be excused for that.
Okay, but the best practice is you get consent and redact some information.
Thank you.
So,
Thank
however,
you,
you have, the writings show you are able to clearly identify issues, you are able to apply the law precisely, though you tend to use case law minimally. You don't seem to be using decided cases, so we don't know whether your conclusions in the submissions and legal opinions are personal or guided by legal principles.
Thank you, Madam Commissioner.
Not all, but about two
Yes.
of them you've not made, three of them you've not made any reference to any
Yeah,
decided case.
thank you. Thank you for that observation. The constituency that I serve comprises of engineers and accountants, so that I have to speak in a language that is unambiguous, and I try as much as possible to avoid use of legal jargons and case law. I'm normally very minimal, so that they understand the message that I'm trying to pass across. That's why you'll notice in some instances I've not even quoted a case law.
Okay.
Yes,
Now,
thank you.
so I see you also worked at CAJ, which is an Article 59 commission, similar to where I work, my day job, I work at KNCHR. If you look at Article 59, these commissions were, among others, established to investigate complaints and take appropriate steps to secure redress, underline secure redress when human rights are violated. So how is this process, or how is this endgame different from Article 22.1, which gives the power to the courts, the High Court, the courts, to enforce human rights? Are those powers different? The powers of the court and the power of these two Article 59 commissions?
Thank you, Madam Commissioner. I'm looking at, first of all, Article 59.4, that establishes other commissions that are constitutional commissions within the meaning of that article. In the case
sorry,
of...
sorry, I have to, it's not Article 22.1, sorry, Article 23.1. I made a mistake in making reference to the article that seeks to enforce the Bill of Rights.
Thank you, Madam Commissioner. Article 59 establishes other commissions within the meaning of that particular article. And for the case of CAG, this is a commission mandated, that is quasi-judicial, that performs quasi-judicial functions. And the mandate is defined under the CAG Act, where the commission is supposed to check on the complaints to do with maladministration, abuse of power, inefficiency, ineptitude in public service. Once the commission...
So if you just specifically, not just going to CAJ, but generally Article 59 commission. So if you look at Article 59(1)(e), the power of these commissions, which we know there are three, GEC, CAJ, and KCHR, they have powers to investigate complaints and take appropriate redress where human rights are violated. Were you there?
Thank you.
And then now you go to Article 23(1), the powers of the High Court to determine and hear cases or applications for redress or denial, threat to, or generally the powers of the High Court when it comes to the enforcement of Bill of Rights. Do those two provisions of the Constitution, can we say they conflict each other, or how can a person move from Article 59 to the High Court, or the High Court can say you needed to have, first of all, have gone to this Article 59?
I would say that the two articles are complementary in nature to the extent that the work of the commissions is actually to supplement. I would look at it as an alternative justice system within our judicial system, and I would say that the two are complementary in nature. And further, if you look at the objects under which the commissions are established, that is Article 249, it is to protect the sovereignty of the people. And I would say that the functions being performed by the court under Article 23(1) are actually mirroring what is happening under Article 249. So I would not say look at them as two competing entities, but I would look at them as two supplementing entities that they can work together to achieve the ends of justice, and particularly to enhance access to justice as set out under Article 48 of the Constitution.
So can a respondent in a constitutional petition say that under the doctrine of exhaustion, a party ought not to have moved the court, ought to have first of all gone and had their issue addressed by any of the Article 59 commissions? Would that be sufficient? And maybe give an explanation to your answer.
Thank you. The doctrine of exhaustion, I would say that it's anchored under Article 159 of our Constitution. I'm looking at the classical example of the Ombudsman, and particularly on the mandate to address complaints touching on access to information. The courts have over time, over and over again, pronounced itself in terms of the first question is mainly on whether the petitioner has approached the commission, and before even you go to the commission, the petitioner is supposed to have sought redress with the institution from which he wanted to obtain the information from, and should there be difficulties, then they are allowed to go to the Commission on Administrative Justice, and should he be dissatisfied there, then he can move to court to say that he has exhausted the entire administrative mechanism provided for under statute and under the Constitution. But I would say that this is not a bar to a person accessing for a person is trying to access justice. The court will look at a case-by-case basis and allow a petitioner to actually jump the queue and go to the High Court. That's what I would say.
So just in summary, a response to yes or no, so can the High Court say this matter ought to have been handled by a constitutional commission before coming here? Would the High Court be proper in saying that under the doctrine of exhaustion, you ought to have first of all handled your matters at any of those Article 59? If it's an issue of discrimination, handle it at National Council on, and GEC before bringing it to the court. Would the court be right in doing that?
Yes, I would say that the court would be right.
Okay, thank you. Thank you, Chair.
Thank you, Chair. Good afternoon. once again.
Good afternoon, Your Honor.
Okay, so there are two overriding objectives of case management in a criminal trial. What are they?
Two objectives of case management in criminal trial. I would say that the first objective is to achieve, to ensure that the matter is, the case is heard expeditiously.
Yes.
And in a just manner.
Excellent.
Yes, thank you.
It's those two, actually.
Thank you.
Yes. And so there are many ways we go about criminal trial to ensure that, especially when you're doing case management, to ensure that those two objectives are achieved. Now, one of the ways is to ensure that the accused is treated fairly. And in treating them fairly, there's the question of bond. So imagine you are a judge and a matter is before you, and the prosecutor has made passionate submissions against granting bail or bond. What are the factors you would consider in determining whether or not to admit the accused to bail?
Thank you.